Thank you, Mr President. I rise to support the motion that this council requires the President of the Legislative Council to request an investigation by the Equal Opportunity Commissioner of all instances of harassment, victimisation and inappropriate behaviour committed by the member for Waite, Mr Sam De Luc MP, in December 2019, and note that I move the proposed amendment standing in my name that after December 2019, insert, quote, and invite the Equal Opportunity Commissioner to make recommendations for reforms to facilitate the handling of harassment in the parliamentary workplace.
Seconded.
Thank you, Mr President. I rise as somebody who was at the Crossbench Christmas drinks, called the Nightmare Before Christmas because it was December 13 and had a Halloween theme. Of course, it has had become the Nightmare After Christmas for far too many of us. And I just want to start by noting an email that was sent on sent on the 14th of February from a constituent that I was forwarded just this morning by my staff. And that email reads, "Dear Ms Franks, I feel compelled to write to you about the situation you find yourself in. This has brought back horrible memories for me. I've been sexually assaulted in the workplace and also faced homophobia. I was 19, it was the late 80s, and I didn't feel that I could say anything against the person doing this, and my only option was to remove myself from the situation, so I left my job. I would hope that 30 years later we would not still be having this conversation." He goes on to say, "This is not okay. Examples need to be set. Expectations need to be set." Now, he also concludes with, "You are the voice of so many people, and we need your voice to make change, to send a message that at any level this is not okay, this will not be tolerated. You have a lot of support from people you have never met. Stay strong and do it for us. #MeToo. I would hope that everyone in this place feels that those words apply to them, that this will no longer be a place where parliamentary privilege in the future will no longer be a protection against complaints of sexual harassment, that this is not an harasser's haven, and that we set the standards that are as high as any other workplace in this state." I thanked him for his words because I've also received phone calls to my office and emails about what a nice bloke the member for Waite is. I've had people abuse my staff for me speaking out. I've attended an event where a constituent of Mr De Luc's expressed her concern that he was having a hard time. There's now on the whiteboard in my office my reply, which was, "I know, I was there. I was not the only one there. And in fact, the harassment that I suffered is incredibly minor compared to that inflicted upon a number of people in this work environment. Sexual harassment, racial harassment, prejudice, bigotry, homophobia are all things that are not tolerated in any other workplace in this state. They're all things that there are lines of responsibility for, that there are standards and expectations that are expected, and that, should they be present by somebody in that workplace, it would be, "Don't come in next Monday." That would be the response. But in this place, we know it is a political environment. I'm not a lawyer, Mr President, as you know, but I am somebody who's previously complained to the Equal Opportunity Commissioner about sexual harassment in this workplace. I complained in 2017 on the 25th of November. On the 29th of August 2018, I finally received a written response to my complaint. That read, "Dear Ms Franks, I am writing about your complaint dated 25th November 2017 about the then Speaker of the House of Assembly. I administer the Equal Opportunity Act 1984 SA, the Act which makes many types of discrimination unlawful in specific areas of public life. I understand that you feel the treatment you have experienced may seem unfair. However, I can only make inquiries into your complaint if it is covered by the Act. It goes on to outline my complaint and then reads, Section 87 of the Act contains the provision relating to sexual harassment and outlines the various areas of public life the prohibition relates to. Section 87, subsection 6C, specifically relates to members of Parliament and covers complaints by members of an MP's staff, an officer or member of staff of the Parliament or other persons who in the course of employment perform duties at Parliament House. The method of dealing with complaints regarding allegations of sexual harassment by MPs is set out in Section 93AA of the Act. This states the complaint must be referred to the appropriate authority, which in this case was the Deputy Speaker of the House, by letter dated 22nd December 2017. The Deputy Speaker advised that the allegation did not come within Section 87(6)(c), as the section did not apply to an allegation made by another Member of Parliament. As such, she advised she would not be investigating it, nor deciding whether it impinged on parliamentary privilege. The Deputy Speaker's decision means that Section 93AA(d) applies, and I thereby need to decide whether the complaint can be dealt with under the Act. Initially, I believed that in order to do this, the Deputy Speaker had to decide on the issue of parliamentary privilege. However, after receiving further information, including a relevant section of the Hansard record, I no longer believe this is necessary. The Hansard record indicates that there was some debate on the bill in 1996-7, which amended Section 87 to include members of Parliament. The opposition at the time expressed disappointment that a recommendation of the Select Committee on Women in Parliament was not taken into account by recognising that sexual harassment can occur between one MP and another. The then Attorney-General was clear on this point. He quoted from the review of the Equal Opportunity Act by Mr Martin QC, which indicated the issue of power inequality was central to consideration of the areas of public life where the provision relating to sexual harassment would apply. He said MPs, quote, are in a different position from the normal workplace participant. They are frequently adversaries in the public eye. Other means of coping with offensive behaviour are readily available, and there are dangers associated with an attempt to intrude into these relationships. That's page 1708 of the Hansard. The Equal Opportunity Commissioner goes on to write, the Attorney-General indicated the government agreed with that view and opposed any attempt to extend the Act to cover sexual harassment by one Member of Parliament against another. In my view, this debate and the wording of the amendment makes it clear that Section 87(6)(c) was not intended to apply to complaints of sexual harassment by one MP against another. It is further my view that given Section 87(6)(c) is the section which specifically applies to MPs, then Section 87(1), by virtue of this fact and its wording relating to sexual harassment in the workplace, does not apply to the situation you describe in your complaint involving the actions of the Speaker. You evidently believe an MP should be able to utilise the provisions of the Act to make a complaint of sexual harassment against another MP. However, my view, this is the view of the Equal Opportunity Commissioner, my view is that the situation you describe does not come within the Act in its current form. As such, I do not have jurisdiction to inquire into or examine the substance of your complaint. Although I do not believe this is a complaint within my jurisdiction, the subject of sexual harassment in all areas of public life is of concern to me. I continue to promote awareness of the issue, and I am always grateful for the opportunity to reflect on whether the current form of the Act is an appropriate reflection of community values and expectations. Furthermore, I will continue to dialogue with the government in relation to the question of possible future amendments to the Act. Signed, Dr. Nikki Vincent. So when this happened, I knew that we had little recourse in terms of those of us who were MPs to make a complaint to the Equal Opportunity Commissioner with regards to another MP. In the aftermath of that party, where many of us chose to stay out of the way of a gatecrasher who behaved so offensively that people were leaving, who behaved so offensively that he was asked on several occasions to leave, who behaved so offensively that he would not have been welcome back at work in any other workplace in this state, I knew that in many cases we had no recourse. One of the things that my friends had asked me in following days was, why didn't you call the police? Well, Mr. President, without either the President or the Speaker allowing the police into the building, we couldn't have called the police. We had no power to have them enter, or just to make that threat that could potentially cause embarrassment. I am on record at the time, this week noting that one of the people at the party attempted to shame him by taking a photo of his behaviour. He then made her delete that photo from the phone. I raised this because it showed that he actually had knowledge that his behaviour was inappropriate at the time. So to hear apologies that include journeys of recovery, to see apologies on Twitter that do not actually acknowledge the actions and the hurt and the harm that is being caused here, that do not acknowledge, other than those who have been vocal in our complaints, that there has been incredibly large ripples into this building of people who work in this place, people who have a pit of fear in their stomachs that they may run into him, people who avoid going to places where he may be, people who, upon coming into this building, need to compose themselves, to deal with the anxiety, the trauma and the stress that those events of that night have created for the last 2 months in their lives. Now, like that man who sent that email, often that anxiety, that trauma, that stress comes because of a range of other events that have happened in people's lives, and I want to acknowledge that. And I think that we should all acknowledge that nobody comes to these situations without a range of things that they live with, live through, and that we all carry with us. I have spent weeks counselling people, supporting people, being supported by others, and watching a process that has fallen far short of what would happen in any other workplace in this state, watching a process that has been a farce, watching a process that has been completely powerless to provide sanction, and watching a vacuum of leadership. We often say in this place that hard cases make bad laws, but actually we need good laws so that we don't get to these points where we have hard cases. And I do move my amendment to this motion, noting the Greens are no saints in sexual harassment in the workplace, and in particular a former member of the Greens in New South Wales who another member of the Greens had to accuse in the Parliament, using parliamentary privilege, of that harassment before the then leader, Senator Richard Di Natale, called for his resignation. But I reflect upon the political nature with which this matter has been handled. If it is the case that members of a political party went and backgrounded media about this, they should reflect upon their actions, because those people who attended the party, including myself, did not want this run through the media, Mr. President. And in that, while it was, in the end, the only recourse for action, the only recourse for a real response, it has re-traumatised everyone in a way that would not happen in any other workplace. Imagine seeing your life on the front page of the paper when you did nothing to create that news story, that it was not your actions that were the harassment. You were simply subjected to them and you were already living with the trauma, and then you're re-traumatised on the nightly news, the front page of the paper, and the radio waves, day after day after day, because we do not have processes in this place that anticipate these situations when we know that these situations have been happening for years, and if we don't do something about it now, they will continue to happen without appropriate remedies, without appropriate workplace protections. So I urge members to take the Equal Opportunity Commissioner's offer to assist us up. She's been making it now for years. She should have been offered the opportunity to assist with this matter. In my early conversations, after I made a formal complaint, I was informed by the Speaker that he was in conversation with the Equal Opportunity Commissioner. That was in the first week of this year. I waited and I waited and I waited and I waited well over a week from that conversation to then read in Daily, again in the media, that the Equal Opportunity Commissioner was going to have nothing to do with this investigation. And there was then another several days before I received my invitation to participate in the private investigation. And I think I'm possibly unique in this place in that I've participated in both the private investigation and the police investigation. And I will put on record right now that I participated in that police investigation just a few short days ago, and at the end of my participation I asked the detective sergeant whether or not I should now no longer make any public comment on the matter. And that was not the case. He said as long as I didn't go to the particular evidence in the statement that I had given, which was on a specific area of the matters that happened that night, then there was no reason that I should not talk publicly. And he was certainly aware that I was going to talk this afternoon to this particular motion, and there was absolutely no advice from him that I should not continue to speak up and speak out. I want that to sink in with people, because I'm gobsmacked that this week we have now seen the private investigation suspended. It's almost 2 weeks since I sat down with the private investigator and I gave him 11 names during that session with email addresses and phone numbers for him to contact. And it wasn't until Friday that those people were contacted, Friday the 14th, just gone by at the end of the day. That doesn't give me great faith in a process where I would have thought if you have an independent private investigator, that that person should be enabled to talk to whoever they want, whoever they saw fit, and follow the train of that investigation as quickly as possible so as not to further continue the trauma in this place. But it was confirmed in the other place, Mr. President, that the Speaker had decided to veto, or would not rule out veto, sorry. Now, I just cannot for the life of me see why the Speaker needed to have the names run past him by the private investigator if this was truly an independent process. But I will also acknowledge and thank the Speaker, particularly for a conversation today, which was brief, but previously I've had excellent and fruitful discussions with the Speaker about raising the standards in this place. Previously he has been very supportive, and indeed his actions have been to curtail harassment in the other place and in this Parliament. And so I do have some level of goodwill left, but I certainly think that this process has been very, very far from perfect. But I point out in the correspondence that I received from the Speaker, following up from my questions to him about how the private investigation would be undertaken, he stated, as Speaker, I do not have a formal role expressly in relation to investigating and resolving complaints about alleged sexual harassment by a member of the House of Assembly. However, by virtue of my position as Speaker, I am responsible for the general purpose of maintaining order, whether that be good governance of the House of Assembly and more broadly the parliamentary precinct, including the welfare of those people who work and visit Parliament. To fulfil my role as one of maintaining order, I feel it is necessary to undertake some investigations so that I can form a preliminary view as to whether the allegations of sexual harassment by the Mr de Luc are well founded. I think that was meant to read by the member for Waite, but anyway. It is for this reason I am seeking the assistance of an experienced independent investigator to assist me with this task, noting that neither the investigator nor myself have powers of compulsion when dealing with this matter. Relevant people can be invited to participate, answer questions or provide information, but no powers of compulsion can be exercised. Based on the findings of the investigation, my preferred course of action may be to invite relevant persons to participate in a conciliation or mediation process. If there is agreement, I would ask an independent person to facilitate the conciliation or advise me on how best to conduct the conciliation. As I have no formal power to resolve the matter, if conciliation fails, there is nothing more I can do. To assist that reflection, I seek clarification on some... It then goes on to say that the terms of reference for the investigation are to evaluate and consider the evidence sourced in respect to the alleged behaviour of Mr de Luc that took place on the 13th of December 2020 at a Christmas function organised by the crossbench members of the Legislative Council in the Council's lower ground corridor and a Liberal Party Christmas function held on the same day. In response to my question whether the purpose was only to confirm the events and sequences of events, the response from the Speaker was, yes, the scope of the independent investigators' inquiries will be to endeavour to obtain full particulars as to what took place concerning the alleged conduct of Mr de Luc and to provide a report for the Speaker's consideration. With regards to then my question as to what would then happen with that report, and it said, I will be the sole recipient of the report, that being the Speaker. In the first instance, the report will be provided to me. When I've had the opportunity to review it, I will determine whether and to whom the report will be released. And finally, of note for this particular debate, what sanctions are within the remit of yourself as the Speaker, was my question to him. And the response was, as Speaker, I have no authority to impose any sanction on Mr de Luc if the alleged behaviour complained of is proved to be founded as a result of the independent investigation. So I'm already on public record as saying I think the investigation process is a farce. I think very highly of the private investigator undertaking the job. I found him professional, thorough, and I believe that the report will be of great use to the Equal Opportunity Commissioner, and I would encourage strongly, through you, Mr President, that the Speaker consider that and also consider resuming the work of that private investigator in pulling together that report. And one of the reasons I say so is we've already been traumatised enough in this place. I've had to tell the story twice, and if there is a court case, we may well see that process unfold. But in the meantime, that is only on one very small aspect of that night, and it provides no remedy and no recourse for those people currently struggling with working in this place and feeling that this place does not support them, feeling that perhaps they should look elsewhere for work, feeling that perhaps it's just easier to give up. But I urge those people not to give up, and I urge the members of this council not to put them in a position where they feel like they should give up. I don't doubt for a second that processes will be used politically. I don't doubt for a second that both sides of politics that are not the crossbench have seen this through the political prism, that people have played games with it. And as one of the anecdotes goes, to the new member that sits on their bench and looks across the chamber, "Oh, look at that," they say, "there's the enemy on the other side, and we know that we have the bloodline in the other place." To which the wizened old politician says, no, that's not the enemy. The enemy's sitting next to you. That's just the opposition. I know that the political games played on this are many-layered, and that as crossbenchers, we are the least powerful members of this parliament in terms of these situations. We do not have, and I'm getting a snide little look now, but Mr. President, I shall ignore it. If I had a problem with a colleague, I could use my internal party processes. If my problem was with a member of another party, I do not have those internal party processes at my disposal. But I'm sure that every member of this place knows at least 2 or 3 stories of inappropriate behaviour by people in their own parties, where they cross into another infliction on another person who's not in their party. That person has very little recourse. When it's done in public life and there are no processes in this parliament, the only recourse a person has is either to give up or to go public and to shift the shame that they've been made to feel onto the perpetrator where it rightfully belongs. That is not a situation that anyone who has been the subject of victimisation, bullying, harassment, racism should have to take on. They should have the very full and fierce protection of the law behind them and clear, transparent processes that will support them on their journey of recovery. I could say much more, Mr. President, but with those few words I support the amended motion, and I flag that in the coming weeks I will bring before this place a bill for a Standards Commissioner that I hope will see us create better processes in the future.
Call the Honourable Treasurer.